Hello, welcome to the Self-Learning Podcast by Dr. Sushma Singh. Let us start discussion on Unit 10, Legal System and Judiciary. And our topic is Judicial Review and Public Interest Litigation, PIL. Judicial reviews mean the power of the judiciary to pronounce upon the constitutional validity of the acts of public authorities, both executive and legislature. In any democratic society, judicial review is the soul of the system, because without it democracy and the rule of law cannot be maintained. Judicial review in India is an integral part of the constitution and constitutes the basic structure of the constitution. The whole law of judicial review has been developed by judges on a case-to-case basis. Consequently, the right of seeking judicial review depends on the facts of each individual case. However, there cannot be a review of an abstract proposition of law. Though the judicial review does not find the mention in our constitution, this power has been derived by the judiciary from various provisions. Firstly, judiciary power to interpret the constitution and especially the limits on fundamental rights. For example, Article 13(2) that suggests that any law contravening the fundamental rights would be declared void. It is the duty of the Supreme Court to safeguard and protect the fundamental rights of the people, and thus it is invested with the power of judicial review under Article 32 and to interpret the Constitution. The Supreme Court's power of judicial review extends to constitutional amendments. However, constitutional amendment review by judiciary in relation to fundamental rights and its legal validity has been a contentious political issue. Parliament can amend the Constitution under Article 368, but such amendments should not take away or violate fundamental rights, and any law made in contravention with this rule shall be void. Before Golaknath case 1967, the courts held that the constitutional amendment is not law within the meaning of Article 13 and hence would not be held void if it violated any fundamental rights. In Golaknath case, it was settled that all amendments by law 13(3) fundamental rights are transcendental and immutable, so cannot be amended. Nonetheless, to amend fundamental rights, a new constituent assembly needs to be convened, and constitutional amendment is an ordinary legislative power. In 1971, Parliament by the 24th Constitutional Amendment reversed the Golaknath judgment by declaring constitutional amendment made under Article 368 not to be as law within the meaning of Article 13, and the validity of the Constitutional Amendment Act shall not be open to question on the ground that it takes away or affects fundamental rights. In 1972, the Parliament passed the 25th Constitutional Amendment Act, allowing the legislature to encroach on fundamental rights if it was said to be done pursuant to giving effect to the directive principles of the state. The 28th Amendment Act ended the recognition guaranteed to the former rulers of Indian state, and their privy purses were abolished. In the famous Keshwanand Bharti case 1973, the court held that the Parliament could amend even the fundamental rights, but it was not competent to alter the basic structure or framework of the Constitution. The 42nd Amendment Act 1976 declared that the Article 368 was not subject to judicial review by inserting clause 4 and 5 in Article 368. However, in 1980, in Minerva Mill case, court struck down in Article 4 and 5 of Article 368 and maintained that judicial review is the basic feature of the Indian constitution system, which cannot be taken away even by amending the constitution. The Supreme Court since then has been defining the basic structure case by case. Public interest litigation (PIL) is a socio-economic movement generated by judiciary to reach justice, especially to the weaker sections of the society. The idea came from Attito Popularis of the Roman jurisprudence, which allowed court access to every citizen in the matter of public wrongs. The purpose of PIL is not enforced of the right of one person against the other, but to reach justice to the deprived section of the society. The court is not exercising any extra constitutional jurisdiction and is now firmly rooted in Article 14, that is, protection against all arbitrariness and the lawlessness in administrative actions, and Article 21, that provides for protection of life, embodying everything that goes for a dignified living, including rightful concern for others and directive principles applying to weaker sections. The granting of the right to PIL has led to plethora of litigations in the courts, indicative of the development of democratic rights by judiciary. SP Sath has suggested that the Supreme Court has been working under these patterns. Interpretational trust with a view to extending judicial control over other organs of the state to ensure liberty, dignity, equality, and justice to the individual, and greater accountability of the governing institutions. And interpretational strategies with a view to facilitate social change, which would promote greater protection of the minorities, weaker sections of the society, and political and religious dissenters, and innovating new methods for creating access to justice like PIL and Lok Adalat. Now let us move to the next point, judicial reforms agenda. The judiciary must find ways and means to clear burgeoning pending cases. In this, judiciary as an organization needs specialization and differentiation in order to solve the cases. Lok adalats and tribunals must be made more effective. Judiciary must appoint judges on merit basis and all ad hocism must go. As the 10th Law Commission has suggested, constitutional courts and the zonal courts of the appeal may be constituted. A working democracy requires an independent judiciary well coordinated by an effective executive and a responsible legislature. Now let us sum up the unit. In a democracy, the legal system and the judiciary are important constituents within the larger political milieu. The modern judiciary in India derives its sources from the Constitution and acts as a check on the arbitrary decisions of the legislature and the executive. The Constituent Assembly foresaw the significance of the judiciary as an guardian of rights and justice, while the Supreme Court is the highest court of law in India, whose decisions are equally binding on all. The high courts and the subordinate courts ensure justice at the state and district levels respectively. The provision for judicial review and public interest litigation ensure that the rule of law is maintained, thereby providing for a dignified living and a rightful concern for all. Thus, the unit broadly analyzes the structure, process, behavior, and interaction of the judiciary within a broad framework to achieve the goals of development and democracy. Now, let us wind up the session, and we have come to the end of the unit. Thank you very much for engaging yourself with the self learning podcast.